Hey everybody, I hope you're doing well. This is going to just be a little quick stream. This morning I was cruising the streets as we do, and I saw some discussion about the RO with, excuse me, with Craig, and apparently Brittany has also. Hi, Shorty. Thanks for coming in. I appreciate it. I really do. This was very impromptu and thrown together. I saw overnight that Brittany had discussed that she had a criminal complaint filed against her and she needs to appear in court. And then I've seen some follow-up community posts, some shorts, and some comments made, whether it be in chats or underneath some videos. And I noticed just a little bit of confusion, and it is polarizing. I grant you that. Is it online shit talk? Is it actually threats? And let's try to break that down a little bit, because we did go over this before when it came up regarding the C&Ds. It's going to be interesting. And if anything, I hope that it does bring to the forefront that we all need to be aware of the laws and the statutes that regulate our own community, and that while we all want to be free speech absolutists, there comes a time that not everything that you think needs to come out your mouth. And when you're highly agitated, the things that you say, you may be held accountable for. And we went over this with the C&D issue and the intentional infliction of emotional distress and the claims of defamation, and how there was a difference between rhetorical hyperbole and true threats and fighting words. And that was in the civil context. So we're going to just revisit a couple of cases real quickly. Free speech does come with consequences. It does. It does. And those can be civil liability or criminal, albeit possibly misdemeanor citations. It's accountability nonetheless. So I'm just going to expand a little bit on a previous presentation and how it applies to New Jersey, and what that small little nuance is with Section 4C of the harassment and annoyance statute. So we're going to go ahead and jump in. Again, excuse me. Okay. And again, please feel free to leave a comment after the presentation with your thoughts. Share it if you'd like, if you found value in it. Let other people know. And again, none of this is legal advice by any means. This is just a reasonable person having a basic discussion on what's been happening on the internet and doing a little bit of research, okay? So, how words cross the line: hyperbole or true threat? Okay, where are we? I want to take a moment and clarify something important that has come up overnight: the difference between rhetorical hyperbole and what the law calls a true threat. Okay, thanks, Shorty. I'm glad that you're here to listen in. These are not the same thing, and using those terms interchangeably may cause confusion online and offline, albeit unintentionally. In everyday speech, people exaggerate. We do it constantly. We say things like, I'm going to destroy him. She's dead to me. I'll ruin you. If he does that again, I'll kill him. Or welcome to the Thunderdome. Bite the bullet. Again, we're talking about phrases, terms of speech, and again, with the idioms and the colloquialisms of a particular area. Um, but again, when we say these things, while we're being hyperbolic or just using them as a figure of speech, we need to be aware that using these figures of speech in conjunction with your tone, your intent, and the context may have consequences, either civilly or criminally, albeit it could just be a misdemeanor. So let's go ahead and keep diving in. Most of the time, no one believes these things are literal plans. They're being said for emotional emphasis. They're dramatic language used to express anger or frustration. The Supreme Court has actually recognized this. In Watts versus the United States, the court referred to this kind of speech as rhetorical hyperbole, meaning exaggerated political or emotional expression that is not intended as a real threat. It's hyperbole. Even when it's heated, it's generally protected speech. And again, rhetorical hyperbole versus true threats. The concept also arises in cases involving what is a true threat. The Supreme Court has distinguished political hyperbole or jest or joking versus serious expressions of intent or harm. Rhetorical hyperbole and defamation. In law, rhetorical hyperbole is extravagant, non-literal exaggeration used for a rhetorical effect and is protected under the First Amendment, particularly in defamation cases. As such, statements are understood to be opinion, not factual assertion. Statements using rhetorical hyperbole are considered incapable of being proven true or false and therefore are not actionable as defamation, which provides breathing space for the heated or emotional language. And here's some definitions. And again, this is just really quick for this because we did go over this in a standalone live stream earlier. I will go ahead and provide that link in the description for that particular live stream if anybody's interested to watch it later on. It is the IED and C&Ds and invasion of privacy long form live stream. True threats versus rhetorical hyperbole. The distinction. The U.S. Supreme Court has established that true threats fall outside the scope of First Amendment protections. This contrasts with rhetorical hyperbole, which is considered protected speech. With true threats, it's the speaker's intent. The speaker must have subjective understanding that their statement would be perceived as a threat, even if the speaker doesn't intend to carry out the act. That falls under the true threat. Whereas rhetorical hyperbole is the speaker's intent to make an exaggerated, non-literal point, such as a joke or something we see in political commentary. Under a true threat, we have seriousness. Statements must convey a serious expression of intent to commit an unlawful, violent act against a particular person or group, whereas with rhetorical hyperbole, the statement is taken in context, do not convey a real possibility that violence will follow. And context, and again, I really emphasize context in a lot of my streams and a lot of my presentations, because context online is so very important across many genres and many communities or sectors, and forums on the internet, because because we are typing a lot of the time, we don't get the tone, or we we're missing out on our nonverbal cues that we have when we're in person, and we're still also missing out on them if we're not, as they say, cammed up and speaking to the camera for people to see us. So context is so very important. An implicit or explicit threat can be judged serious based on its context, such as a speaker's awareness that others could regard their statement as threatening. And again, this goes back to what's called the reasonable person. What would a reasonable person think if they heard this? And unfortunately, the reality of this particular situation is that there have been some things that, in my opinion, as a reasonable person, have crossed the line. So let's continue. A statement like, "I'm going to end you for showing up late," would be viewed as hyperbolic, a figure of speech in context. Whereas someone saying, for example, "You're my enemy, and my enemies have a habit of disappearing. They end up dead." That's almost an assertion. That is being said as a statement of fact. So where are we drawing the line? Was that the intent? Was the speaker's intent to be like, "Listen, we've gone beyond the FAFO stage. We're now into ramification," which is the physical level of find out. So again, and we've heard things like, first I'm going to take your channel, then I'm going to take your life. I'm sorry, excuse me? How else do you take that? That's not said in the context of, "Hey, I'm taking your channel, now I'm going to take away your livelihood." No, your life. There's an escalation of speech. There's an escalation of intent. And there's an escalation of what they want the listener to experience, to feel. And while we're going to get into feelings and the distinction between intent in a legal aspect, it's still an important sentiment to understand that your words do carry weight. And when that weight reaches a specific person because it's targeted, that's going to come into play as well when we get into the specific statutes here. So moving on, the distinction, and to summarize, what is a true threat? Legally, a true threat is very specific. It is a serious expression of intent to commit an unlawful act of violence against a particular person or group. For speech to cross that line, courts look at, is there a specific target? Is there a specific harm described? Does the context suggest seriousness? Your Swiss cheese next. Okay. When you bring in the racking of a firearm as you're speaking, that suggests seriousness, because the speaker was engaging in an act that to the reasonable person would be seen as, one, threatening, two, intimidating, and the is done to instill on that person's heart fear, worry, concern. Okay, so when a reasonable person interpret this as a genuine intent to cause harm, it's not about whether someone felt offended. It's about whether the statement communicates real intent. Hello, lab rat. Words are not going to break my neck or give me punch-a-roons. Not everyone has to respond the same, and it's a choice whether to be offended or to have some deeper understanding. I agree. And that's why the bench, the court, makes the distinctions. And hi, Music City Mom. And that's why, again, it's very important to understand the statutes where you reside. And it just pulls us back again to take that moment for what we're putting out into the ether when you're being targeted. Because on the internet, we don't always know where somebody is. We don't know, do they have neighbors somewhere? And that's for the court process to figure out. So there are protections, and that's why it's important to go over this. And I agree, words aren't kicking my door in. Okay. However, and this is where my own bias comes in, I also understand that words over a prolonged period of time stating that, you're gonna take one between the eyes one of these days, and you can't watch your kids 24 hours a day, while they are words spoken on the airwaves, doesn't change the fact that one day the person making those threats, or what I interpret as a threat, aren't going to show up at my door. So that's why it's context, and you have to look at the whole picture. And has this gone beyond shit talking on the internet? And that's what we're here to find out. Again, because at this point, with this particular situation, as it pertains to Julie Skolnick at this point, is she presented something. Hi, All Signs. Thank you for coming in. She presented something to the court in her local jurisdiction that initially, on paper, met a specific threshold for the citation or the hearing or what have you to be scheduled. And now it's incumbent upon Julie and AWBJ, their counsel, to discuss it, debate it, say, wait a minute, this is the statute, but this is to put all these pieces together. So we'll get there. We're getting there. But I appreciate your input, Lab Rat, because I understand exactly what you're saying. And in the context of restraining orders, we went over this before as well. The burden to show that a restraining order is necessary is placed on the individual making the complaint, the victim of the online abuse, so to speak. Generally, when getting a restraining order, the individual making the complaint must show that immediate or irreparable injury, loss, or damage will result to them if the order is not issued. A victim seeking a restraining order based on a complaint of cyber harassment must demonstrate that the harasser's conduct is knowing or willful, is repeated such that it forms a course of conduct, and we've talked about this in the past as well, and places a reasonable person in fear for his or her safety, or causes a reasonable person to suffer emotional distress. And it is a combination of things. It's like, we can have flour and water, but that's not necessarily going to make bread, or make a specific type of bread. Or flour and water and sugar isn't going to make cookies. You need all the ingredients to 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 form the pie. I think you all understand what I'm saying here. Courts are very reluctant to ever issue a restraining order that limits speech. The plaintiff will be expected to show that they are seeking to restrain conduct and not speech. That's so very important. And again, we went over that in greater depth in a previous presentation. But but these last two slides are important just to bring the information back to the forefront, get your mind thinking, and to put you in the mindset going forward, so we can discuss these concepts. Okay, so what we have found is that what Julie has filed or made a complaint of is something called a lesser included offense under a New Jersey statute that is harassment and annoyance. Okay, I've got the link there for you. I will also go ahead here. Let me go ahead and put that in the chat for you guys as well. One moment. And what I'm actually going to put in is the what this, I believe New Jersey would call it the same thing, but it's the sheet that the counsel gives to a jury, or is handed to a bipartisan body of individuals, like if it's a arbitration, like not a sentencing sheet, but it's to understand the law that's being argued and has been argued to either the judge or to the jury, so you can understand the wording and so forth. And I will go ahead and link that PDF. You should be able to see it here. Let me go ahead and, okay. Yeah, it's www.njcourts.gov, NewJerseyCourts.gov/sites, sites/default/files/charges/harass.pdf. That should pull up front facing, but we'll get into it. I've got it all listed on another slide for you, broken down. Okay, so I want to clarify something that often gets blurred in these heated discussions: the difference between feeling threatened and something meeting the legal definition of a threat. And I think that's where LabRat is wanting to make the distinction as well in their previous comment. Those are not the same thing. When someone says, "I feel threatened," they are describing an emotional reaction. That feeling can be real, intense, valid, rooted in personal history. Given I shared a little personal bias that I had towards certain words when they're used. So that would be rooted in a personal history, influenced by tone, repetition, and again, context. Feelings are internal experiences. They don't require legal standards to exist. Two people can hear the same statement. One may feel alarmed. Another may interpret it as an exaggeration. But an emotional impact will vary. When we move from "I feel threatened" to "this is a threat," and again, I will use what I used the other day. Welcome to the Thunderdome. Brittany said, "Did you see that? Are you threatening me? Is that a threat? Did you see that? That's a threat." No, that is a figure of speech. It's an idiom. It's, she's involved in a flame war. And unfortunately, the flame war has gone legal between her sending out multiple C&Ds to former moderators, to other creators. She signed litigation for an injunction and a civil RICO. She was involved in a declaratory judgment based on a C&D. You know, her other half has a temporary restraining order. Now she's got another complaint. We're reaching a boiling point, or we are at the boiling point. But at the same token, it's as if she is the frog that's been sitting in the simmering water, not realizing that she's in this flame war, and that there's not going to be consequences for what she allows, and a continued and this could be said for many other people as well. Right now, we're focusing right here on the situation with Brittany, because again, I saw a misinterpretation, and I just want to bring it to the forefront so we can discuss it again. Okay, we move from "I feel threatened" to "this is a threat." In the legal sense, we leave the realm of personal feelings and enter the realm of legal criterion. The law asked, was there a serious expression of intent to cause unlawful harm? Was there a specific target? Was there specificity about the harm? Would a reasonable person interpret it as genuine intent to carry out violence? It is not enough that someone felt afraid. The question becomes whether the speech objectively communicated a real threat. And at this point, because there is a court date, this will be up to each side to argue. It's not for us to litigate in the court of public opinion. It's beyond that now. It's going to go before a judge. We can have our opinions, but our opinions are going to be based a little bit on our own confirmation biases at this point, if you've been engaged for the last 2 years of watching the back and forth and the tit for tat and what's happened. I mean, that's just human nature. That's just how it is. That's just what we're liable to see. So back on target here. What if someone says something vague but intimidating? Vague language alone is usually insufficient for a legal threat. Specificity and seriousness are key factors. Can repeated hyperbole become threatening? Yes. Context, repetition, targeting, and escalation can change the interpretation. Patterns matter. Patterns matter. And that's patterns matter. That's conduct. A continued pattern of conduct becomes established behavior. And that's how it is in the legal framework and in the context of law. Who decides if something is a true threat? Ultimately, the courts do. The courts apply established legal standards using the reasonable person test and the intent considerations. Okay, right. Okay, there we are. Excuse me. Back to the context. Why context matters. Tone, setting, repetition, and escalation matter. A single hyperbolic comment in a heated discussion is usually treated differently than repeated targeted messages directed at someone over time. Context determines whether speech is reckless exaggeration or something more serious. Why this distinction matters in online spaces. Online communities typically will amplify emotion. It's easier to become more animated in our speech and commenting, and while we're commenting, words lose their tone. Screens remove facial expression and the nuance. As a result, dramatic language can look more severe than initially intended. At the same time, labeling every heated statement as a threat lowers the threshold, the real impact for what those words really mean. And that can inflame conflict even further. Precision matters. Proper use of terms and even words themselves matter as well. We can hold people accountable for their reckless speech without labeling it as criminal behavior. Conversely, it's so very important to know you yourself when you're getting dangerously close to crossing the line of when words become threats. So I've provided some resources here for you. The most recent Supreme Court case is Counterman v. Colorado. This recent case refined the standards. The court held that for speech to qualify as a true threat, there must be at least recklessness regarding whether the statement would be perceived as threatening, meaning it's not just about how the listener feels. There must be some mental state showing disregard, for the threatening nature. This strengthens protections for the hyperbolic speech or hyperbole. Specifically regarding New Jersey, the New Jersey reference cases per the statute, harassment and or annoyance. You want to see State versus BH, 290 New Jersey, Superior, page 588, 597, Appellate Division from 1996. It's revised in part and affirmed in part. 149 New Jersey 564 1997. The subsections of the statute address categories of conduct which can be broadly described as communications, physical contact, and course of conduct. The Supreme Court, has limited the scope of the catch-all provision of the New Jersey statute 2C 33-4A, B, and C, any other manner likely to cause annoyance or alarm to preserve the statute's constitutionality. The court held that a communication under that provision must intrude upon a legitimate expectation of privacy. State v. Hoffman in New Jersey, 564, 588, 83, in 1997. However, the Appellate Division had held that the degree of annoyance under subsection A must be serious, not merely meddlesome or vexing. State versus BH, 290 New Jersey Superior Decision at 598 concluded the Supreme Court rejected this holding, noting that subsection A of the statute does not include the word serious, while subsection C does. So, and that is what is being relied upon for the complaint that was made, against Brittany. So let me go ahead and pull that for you guys and give you the link. Okay. Paste. There you go. And one more. Okay. All right. So there's that. I hope this helped clarify a few things, and it has pointed you in the right direction for some cases to look at, some law to distinguish and interpret on your own what may be going on. But to just arbitrarily say, it's bullshit, it may well ultimately be just bullshit. But in the interim, let's be mindful on how we're speaking about it, because if for one person we're stating that you're going to lose your channel, then you're going to lose your life, is taken as a serious threat, well then when another person says, my all my enemies end up dead and you're now my enemy, watch out, is the same you know, let's again try to take personalities out of it. But again, it could all just be flame wars. It could all be hyperbolic. It's at this point, now it's up to the courts to decide going forward. So having our opinions is great, but let's try to base some of our opinions on what the law states and not our own emotion, I guess. So I hope this has been helpful. And if you have any comments or suggestions or anything else you'd like to discuss, go ahead and place it in the replay in the comment section. I thank all of you for being here today, and I will see you next time. All right, and bye.